Let me wait until that gets started. Okay, we are live. Welcome everyone to Courtroom 3 of the Northern Colorado High School Mock Trial, Round 3. I want to start today with a brief introduction of each individual in the courtroom. Students, I'm going to call out each role. So as I call out the role, just introduce yourself. Don't tell me all the roles that you're going to be doing so that we can walk through every role. That'll make it easier for the scorers to get your name down on the score sheet. Can everybody hear me okay? Okay, great. Okay, great. And scorers, as the students are saying their names, you can add that information into your score sheet. So first of all, student who's doing the prosecution opening, could you please state your name and your team?
I am Sophie Harrison, and I'm on Team Pac-Man.
Thank you. And the student doing the defense opening, could you please state your name and your team?
I am Ariel Damiana, and I am doing the opening for Minecraft.
Great, thank you. And who will be the prosecution counsel number 1?
Good morning. I will be the first counsel for Pac-Man. My name is Kellen Hansen.
Thank you. And who will be the defense counsel number 1?
Good morning once again. My name is Ariel Damiana, and I am doing the Directive Avery Becker, so difference number 1.
Thank you. And prosecution counsel number 2, please introduce yourself.
I'm Sophie Harrison, and I'll be doing prosecution counsel number 2.
Great. Defense counsel number 2.
My name is Reese McKinney, part of Team Minecraft, and I'm defense counsel number 2, doing the direct examination of Taylor Perkins.
Thank you. Prosecution counsel number 3.
Good morning. I'm Jade Garcia. I'm on the Pac-Man team, and I'm doing prosecution counsel number 3.
Thank you. Defense counsel number 3. Oh, I can't hear you, Colton.
My name's Colton Littlewood.
There you go.
Of Team Minecraft, and I'll be doing defense counsel number 3.
Thank you. And prosecution witness number 1.
Good morning. I'm Pac-Man's Anna Sophia Hoba. I will be portraying Jordan Markowitz.
Thank you. Defense witness number 1.
Good morning. My name is Sadie Faulkner. I am on the Minecraft team, and I will be portraying Avery Becker today.
Thank you. And prosecution witness number 2.
Good morning. My name is Bella Hoba from the Pac-Man team, and I will be portraying Kyle Kuzak.
Thank you. Defense witness number 2.
Good morning. My name is Dylan Schneider of Team Minecraft, and I will be portraying Taylor Perkins.
Thank you. And prosecution witness number 3.
Good morning. My name is Lola Cheney from the Pac-Man team, and I will be portraying Alex Cifuentes.
Thank you. And who will be defense witness number 3?
Good morning. My name is Evan Gravdahl on Team Minecraft, and I will be portraying Blake Van Owen.
Thank you. And who will be doing the closing argument for the prosecution?
Kellen Hansen for Pac-Man.
Thank you. And who will be doing the closing argument for the defense?
Colton Littlewood for the defense.
Thank you. And prosecution timekeeper, please introduce yourself.
Good morning. I'm Camille Vaughn, and I'm timekeeping for Pac-Man.
Thank you. And defense timekeeper, please introduce yourself.
Hello, I'm Rosa Fabian, and I'm the Minecraft timekeeper.
Great, thank you. Once again, I just want to remind everybody that only the presenting attorneys for the prosecution and the defense and their witnesses, plus the judge, and the scorer should be in this Zoom room. If you're not participating or you're a parent or a coach or a spectator, you need to watch through the live stream link. Also, only those attorneys that are presenting for prosecution and defense and the witness that's currently testifying, plus the judge, should have their camera and microphone on. Everybody else can mute and turn off their cameras. We do have the Zoom settings on so that if you don't have your camera on, you won't show on the screen. Keeps it a little bit cleaner for folks watching on the live stream. Make sure that you are muted when you're not presenting so that we don't get any feedback or stray noises. Timekeepers, you may come on to the screen, turn on your camera as needed to alert your team at the appropriate times. Okay, that's all the announcements I have. And if no one has any questions, we'll go ahead and get started. I'm going to turn the courtroom over to the Honorable Judge Kearns. Mock trial is now in session.
Good morning, it's Judge Kearns. Let me just confirm for the record that both Pac-Man and Minecraft are ready to proceed to trial. On behalf of Pac-Man, are you ready to proceed?
Yes, Your Honor, after a few pretrial matters.
Certainly. And Minecraft?
Yes, Your Honor.
Thank you. So with respect to those pretrial matters?
Yes, Your Honor. First of all, the prosecution requests that we may assume the witnesses to have access to the exhibit packet to reduce the need for screen sharing.
We would like to request the same, Your Honor.
That's granted. Thank you.
Second, the prosecution requests that, if there is no objection from the defense, that time used to portray video evidence and to show it to the jury not be counted as a section of the direct, and that publishing not be timed, essentially, for video evidence specifically.
I would object to that, Your Honor. I believe that should still be counted as part of the time.
My reading of the rules included that the exhibit and presentation of the evidence was included.
I beg your pardon, Your Honor, I was somewhat unclear. Specifically for playing video evidence, as video evidence is an unusual asset which has only appeared this year and requires unusual amounts of time.
Once again, Your Honor, I believe that the rules are clear that any time used to present an exhibit is supposed to be included in the time.
And that is my understanding as well. So I'll deny that request at this time, and any video presentation will be included in the time necessary.
Thank you, Your Honor.
Your Honor. Finally, or first, I'd like to request that any time left over after the prosecution closing be reserved for rebuttal.
Any objection?
No objection, Your Honor.
That certainly is granted.
And finally, the prosecution would like to share screen to present to the jury the stipulated facts and the jury instructions.
You may do so.
Thank you, Your Honor.
Thank you. Any other issues we need to address them before? Oh, you can do that now. Thank you.
Your Honor, are you content that the jury has been made aware of the stipulated facts and jury instructions?
I am. Thank you. Any other pretrial matters then?
The prosecution is ready to proceed, Your Honor.
Very well. This time we'll have opening statements, please.
May I proceed?
Okay, thank you.
Today, you're going to hear the story of Miss Avery Becker, a young woman who, up until now, has gotten away with everything. She has been manipulative, lazy, disrespectful, and when all else failed, a vandal and eventually a killer. This must end. Miss Avery Becker, a Colorado high school student, was the best lawyer on her mock trial team. She was head and shoulders above everybody else, but she refused to do her work. This attitude infuriated her mock trial coach, Mr. Mackenzie Brackman, to no end. It was downright disrespectful. One day, he had enough. He demoted her from their A team to their B team. However, rather than facing these consequences, Miss Becker found a loophole. She had her best friend, Miss Taylor Perkins, drop out of the team just 1 week before regionals, forcing Mr. Brackman's hand and leaving him with no choice but to let her back on the team. Her plan worked. She was able to attend the regional competition and succeeded in winning 2 awards despite Mr. Brackman's original wishes. After the competition, they had another meeting. Upset that Miss Becker worked around the consequences rather than facing them, Mr. Brackman chastised her. Miss Becker didn't know what to do with this. She wasn't used to this kind of reaction. She was used to getting away with it. No problem. So, in response, she stormed out of their meeting, grabbing a permanent marker on the way. Once outside, she scrawled all over the hood of Mr. Brackman's prized Porsche in permanent marker. This was the straw that broke the camel's back for Mr. Brackman. He expelled her from the team, this time permanently. Miss Becker refused to give up. She tried talking to her teammates. She tried talking to Mr. Brackman himself. She tried even visiting his office. He simply wasn't budging. So Miss Becker began to think, if she couldn't get back on the team, if she couldn't get her way, she was going to make sure Mr. Brackman knew just how unhappy about this she was. So she planned to break in and vandalize Mr. Brackman's home, a plan she even discussed with teammate Alex Cifuentes. Another fit of entitled behavior was in the making. This time, it ended worse than anyone could have imagined. On March 6, 2020, Miss Avery Becker unlawfully entered Mr. Brackman's home at 444 South Flower Street. Upon entry through the back door of the home, Miss Becker was surprised by Mr. Brackman, whom, in the hopes of defending himself, had taken a knife from his kitchen. There was a scuffle, and eventually, Miss Becker stabbed Mr. Brackman in the back before fleeing the scene. Today, you will hear from Detective Jordan Markowitz, whom, with her cell phone technology expertise, will be able to give us the general whereabouts of Miss Becker's phone on the day of the crime. You will also hear from Miss Kyle Kuzak, who has 19 years of crime scene reconstruction experience. She has examined the crime scene as well as all evidence collected there and will be able to paint us a vivid picture of the sequence of events on that day. Finally, you will hear from Miss Alex Cifuentes, a teammate and even a friend of Miss Becker's. She will be able to tell us about Miss Becker's behavior on the mock trial team and reveal her original plans to break into Mr. Brackman's home. In the end, you, the jury, and the judge, the opposing counsel, will be sure beyond a reasonable doubt that Miss Becker is guilty of murder in the first degree and of second-degree burglary. Thank you.
Thank you, counsel. Any opening statements from the defense?
Yes, Your Honor. Good morning, Your Honor, and ladies and gentlemen of the jury. We are complex people with complex problems, and complex problems don't have simple answers. The case the prosecution will present for you today is an attempt to answer a complex problem Mackenzie Brackman's tragic and untimely death with a simple answer. Avery Becker didn't like Mr. Brackman and therefore must have killed him. Simple, right? But what you will see when you look below the surface of the prosecution's case is that their simple answer doesn't make much sense. It doesn't make sense because Avery Becker did not kill Mr. Brackman. The defense will present the defendant, Avery Becker, and her alibi, an alibi that was never investigated into by the police in this case, despite their knowledge of one. Today, instead of speculation on part of the police, Avery will get up on the stand and tell you herself where she was when Mr. Brackman died. She was at the mall with her friend, Taylor, looking for her missing phone. But you don't have to just take Avery's word for it. Taylor Perkins will also tell you that she and Avery were at the mall looking for Avery's phone on the day of Mr. Brackman's murder, March 6th, and had no intention of ever going near Mackenzie Brackman's home, especially since they didn't even know his address. Ms. Becker will also illuminate the nature of her relationship between herself and the late Mr. Brackman, how it was one of expected high school frustration, but certainly not murder. Not only this, but Ms. Becker will also testify to her relationship with Alex Cifuentes, showing that they were hardly close confidants, certainly not close enough to exchange the strain of text messages received by Detective Markowitz. Most importantly, though, ladies and gentlemen, Ms. Becker will explain how her short-lived rash behavior after the regional tournament did not push her further into violent behavior, but rather to immediately see the error in her ways and abandon such behavior. It didn't push her to plan to break into Mr. Brackman's house, but, as she will explain, motivated her to make amends for her past behavior and apologize. Unfortunately, despite her best efforts, she wasn't ever able to apologize, as Mackenzie Brackman was murdered shortly after Ms. Becker will appear before you Ms. Becker will appear before you all today in this apologetic spirit, certainly not one of unbridled violence. The defense will also present Blake Van Owen's investigation into the murder of Mr. Brackman, which takes into account the pieces of evidence the prosecution has ignored. Mr. Van Owen, an experienced private investigator, will explain exactly what happened on March 6th, using detailed analysis on both evidence gathered by the police and evidence the police failed to gather, including the phone records of Taylor Perkins, which show Perkins in the vicinity of the mall at the time of Brackman's murder, lining up with Becker and Perkins's alibi. There is no doubt that this case is a complex one and should be treated as such. However, the prosecution has ignored important pieces of evidence and reduced the complexity of the case to a simple answer. As you will see, the clean lines of Detective Markowitz and Kyle Kuzak's case does exactly this. Today, the defense will show you that Detective Markowitz initially thought a former client could have killed Mr. Brackman, but failed to investigate any of these former clients, their whereabouts at the time of the murder, or even their names. The detective also failed to interview 7 out of the 9 members of the mock trial team, as well as failed to investigate the phone records of Alex Cifuentes. Similarly, the defense will show that Kyle Kuzak failed to consider that the knife used to murder Mr. Brackman and the knives Mr. Brackman had in his kitchen block were of completely different brands. He also failed to investigate the Ring doorbell records of Mr. Brackman, records which were vital to the line of events displayed in their theory of the case. Not only this, ladies and gentlemen, but the defense will present to you both Mr. Kuzak and Detective Markowitz's striking negligence in investigating any suspects besides the defendant, Avery Becker. Although there were multiple other students on the mock trial team, only 2 were contacted. Mackenzie Brackman also had a life of his own as a criminal defense attorney, though Kyle Kuzak and Detective Markowitz have narrowed a complex life into the confines of a single high school mock trial team. As stated before, none of his previous clients were investigated, nor any other possible suspects from other facets of his life. Ladies and gentlemen, today the prosecution must convince you, beyond a reasonable doubt, that Avery Becker is guilty. However, the evidence they have built their case on only reveals a simple answer to a complex problem. The defense will make clear that there are pieces of evidence and alternative theories to the case that point in the direction other than a simple, startlingly clean answer, that true justice was ignored in favor of this clean answer. We implore you to cast not guilty. Thank you.
Thank you, counsel. And the people may introduce their first witness, please.
The prosecution calls Jordan Markowitz to the witness stand. Permission to proceed, Your Honor?
You may, thank you.
Please state your name and spell your last for the record.
Jordan Markowitz, Markowitz.
Detective Markowitz, what is your profession?
I'm a detective with the Denver Police Department.
And how long have you been a detective?
7 years. I've been with the department for about 13.
And do you have a specialty as a detective?
Yes, I have a certificate in cell phone technology and forensic data recovery.
Did this specialty require specialized training?
Yes, it did, from the American Academy of Law Enforcement.
And how often do you use this training?
I use it quite frequently in over 50 cases, and I've downloaded the contents of hundreds of cell phones.
Your Honor, I move to enter Jordan Markowitz as an expert in criminal forensics and cellular phone detail forensics.
Any objection?
Yes, Your Honor. The defense would like to present a voir dire.
You may.
Thank you. Good morning, Detective Markowitz. You did a 3-day training in cell phone technology and forensic data recovery?
Objection, yes, wait, not admissibility.
Your Honor, if I may respond.
You may, please.
This goes to show the extent of Detective Markowitz's training and simply goes to show that her 3-day training may not be able to put weight on her admissibility as a witness.
Thank you. At this point, the court will overrule the objection, allow the questioning under 702. Thank you.
Thank you, Your Honor. Now, Detective Markowitz, would you like me to repeat the question?
Yes, thank you.
You did a 3-day training in cell phone technology and forensic data recovery.
Yes, it was quite extensive, and I've subsequently utilized my training there a great deal over the years.
Thank you. And you don't have any other certified training in cell phone technology and forensic data recovery?
I do not. However, my work as a police officer has...
Detective.
Ma'am, you interrupted.
You don't have... You answered the question.
Badgering the witness.
I'll overrule the objection, but I would ask that there be a question, a pause, an answer, and a pause, please. Thank you.
I apologize, Your Honor.
May I finish my answer?
Yes, Detective, of course.
While I have no other formal training in that area, I have a great deal of experience with the training which I received.
And to clarify, Detective, you don't have a degree in forensic data recovery either.
No, is a piece of paper everything?
You don't have a degree in cellular electronics.
No.
And you never had an update on this course that you took?
I did not.
Your Honor, forensic data recovery is a highly technical area of expertise, and based on the fact that Detective Markowitz obtained her certification from a 3-day course alone, the defense would like to object to this certification as an expert in forensic investigation and cell phone forensics.
Thank you. Any response?
Yes, Your Honor. I would say to the defense that goes to weight, not admissibility. The only requirement for a witness to be qualified as an expert is that they possess specialized knowledge in a field. Detective Markowitz has testified to their specialized knowledge, and the jury can assign weight based on the extent of that knowledge.
Thank you. Court will overrule the objection, find there's sufficient showing pursuant to 702. The qualifications and weight of that testimony goes to the weight, not the admissibility. The court will authorize and designate her as a witness, an expert witness under 702. Thank you.
Detective Markowitz, were you familiar with Mackenzie Brackman?
I was. I've had the displeasure of being cross-examined by him a number of occasions.
And will Mr. Brackman be cross-examining you again?
Unfortunately not. He's now deceased.
How do you know of this?
I was assigned to investigate his murder.
How did your investigation begin?
Passing motorists called the police department. We looked into it, and I was called to the scene shortly thereafter.
What day did this happen?
March 7th.
Detective Markowitz, what did you see at the scene?
I saw Mackenzie Brackman lying just inside his home, dead.
Detective Markowitz, may I direct your attention to the exhibit packet?
Of course.
Detective Markowitz, do you recognize what has been previously marked for identification purposes as exhibits 1 through 4?
I do, yes.
What are exhibits 1 through 4?
Exhibits 1 through 4 are images taken of Mr. Brackman as he appeared on the day which we found him, from several different angles and at different proximities.
Were they taken by your forensics team?
They were, yes.
Are they fair and Are they
Yes.
fair and accurate depictions of Mr. Brackman as he lay at the time?
They are, yes.
Your Honor, I move to enter exhibits 1 through 4 into evidence.
Objection.
No, Your Honor.
Thank you. Court receives into evidence People's Exhibits 1 through 4 inclusive.
Detective Markowitz, do you recognize what has been previously marked as exhibit 5 and 6?
Yes.
What are exhibits 5 and 6?
Exhibits 5 and 6 are images of the knife that we found at the scene. The first as it appeared at the scene, and the second as it appeared when we took it away for measurement.
And are they fair and accurate depictions taken by your forensics team?
They are, yes.
Your Honor, I move to enter exhibits 5 and 6 into evidence.
Thank you. Any objection?
No, Your Honor.
Thank you. Court receives People's Exhibits 5 and 6.
Detective Markowitz, were there any items of particular note around Mr. Brackman's home?
Yes, we found several Ring security cameras, as well as an open knife drawer and a knife block with a single missing knife.
Were expensive items around the home still in place?
Yes.
Detective Markowitz, do you recognize what has been previously marked for identification purposes as Exhibit 7?
Yes, I do.
What is Exhibit 7?
Exhibit 7 is the open knife drawer I found with a selection of different knives in it.
Is it a fair and accurate depiction taken by your forensics team?
It is, yes.
Your Honor, I move to enter Exhibit 7 into evidence.
Any objection?
No, Your Honor.
Thank you. Court receives People's Exhibit 7.
Detective Markowitz, did your colleagues document this crime scene?
They did, yes.
Did all of that documentation survive?
Unfortunately, no. A few images were corrupted somehow, and so we no longer have access to them.
Were you not able to recover those images in any way?
We were not.
Were those images vital to your investigation?
No.
Detective Markowitz, did you find any other evidence related to Mr. Brackman's home?
Yes, several Ring security cameras. I was able to obtain the footage in them by downloading Mr. Brackman's account information.
And how did you download these files?
The Celebrite system. I got his password.
Detective Markowitz, what did these Ring records show?
There were several videos of an intruder approaching Mr. Brackman's home, going around the back, entering his home, and then leaving through the front door.
Did you identify the respective cameras around the home?
We did, yes.
Were you the custodian of these videos while they were in police custody?
I was, yes.
Detective Markowitz, have you previously reviewed the exhibit packet before you?
I have, yes.
Are you familiar with what exhibit 10 through 13 is?
Yes, those are the videos that I was able to recover.
When you last reviewed them, were they fair and accurate representations of those videos?
Yes.
Your Honor, I move to enter exhibits 10 through 13 into evidence.
Objection.
No, Your Honor.
Thank you. Court receives People's Exhibits 10 through 13 inclusive.
Your Honor, permission to share screen to publish the first of these videos to the jury.
You may, thank you.
Can you see it? Permission to proceed, Your Honor.
You may.
Detective Markowitz, how did you become aware of Avery Becker?
I decided to investigate Mr. Brackman's mock trial team as it seemed a likely avenue of possible answers. I came into contact with a student named Alex Cifuentes, a classmate of Avery Becker's, and it was Alex Cifuentes who directed me to Avery Becker as a possible suspect.
What did you learn of Miss Becker?
Ms. Becker had a rather contentious relationship with Mr. Brackman, and as such, I felt that she had a motive.
Detective Markowitz, were you able to acquire Miss Becker's cell records?
I was, yes.
Detective Markowitz, in brief, how do you use call detail records?
Call detail records are useful in ascertaining the approximate geographic location of a cell phone.
And do you have frequent experience using these call detail records?
Yes, I do.
Detective Markowitz, if I may direct your attention to the exhibit packet, do you recognize Exhibit 15?
Yes, Exhibit 15 is a diagram which I prepared outlining the cell towers to which Ms. Becker's phone connected during March 6th and the timestamp for when they connected.
Does the diagram accurately reflect the call detail records you extracted?
It does, yes.
Does it accurately reflect the geographic locations of the marked items?
Yes.
Detective Markowitz, what do we learn from Exhibit 15?
Exhibit 15 indicates that at 12:47, an attempt was made to connect with Ms. Becker's phone at around her home, as well as that another attempt was made while...
Objection, Your Honor. These facts are not in evidence. I believe that the opposing counsel would enter these into evidence beforehand. I don't believe Exhibit 15 has been entered into evidence.
Any response, counsel?
Your Honor, this is the testimony of the witness. Exhibit 15 will speak for itself when it is entered, but the witness also has the capacity to testify about a diagram she created.
Thank you. At this point, the court will overrule the objection. Thank you. You may continue.
Please proceed from the second cell tower, Detective Markowitz.
Yes, the second cell tower records a second attempt to connect with Ms. Becker's phone at 12:55 in an area surrounding the road in between her own home and Mr. Brackman's. The final cell tower indicates 3 different attempts to connect with Ms. Becker's phone during an interval of time of approximately 10 minutes. In an area which contains Mr. Brackman's home.
Your Honor, I move to enter Exhibit 15 into evidence.
Thank you. Any objection?
No, Your Honor.
All right, thank you. Court receives People's Exhibit 15.
Detective Markowitz, based on your analysis, what conclusion do you draw from these call detail records regarding the movements of Miss Becker's cell phone?
I believe that Ms. Becker drove with her cell phone from her own home to Mr. Brackman's, where she stayed for several minutes. Several attempts to contact her occurred during this time.
Detective Markowitz, do you recognize Exhibit 16?
I do. Exhibit 16 is a very similar diagram to Exhibit 15, with the addition of a possible pathway, which, based on my analysis of Ms. Becker's call detail records, seemed very likely as a pathway which she could have utilized.
Is it a fair and accurate representation of the diagram you created?
It is, yes.
Your Honor, I move to enter Exhibit 16 into evidence.
Any objection?
Yes, Your Honor. Under hearsay, I believe that this exhibit is intended as a statement showing the route Avery supposedly drove. Therefore, it's hearsay.
Any response?
Your Honor, this isn't being offered to prove that this is the exact route that Miss Becker took. This is being offered to prove that it is possible for Miss Becker to have made the trip from her own home to the home of Mr. Brackman in accordance with the allotted times.
All right, so the court will rule the objection. It's not going to the truth of the matter asserted, and we'll let you continue. Thank you.
Additionally, Detective Markowitz, did Mr. Becker's phone specifically receive texts?
It did, yes.
Oh, which of the contact points were texts?
The latter three.
Based on your expertise, Detective Markowitz, what do you believe occurred on March 6th?
I believe that Avery Becker drove from her own home to Mr. Brackman's home with the intent to vandalize it. There, she stayed for several minutes, entering the home unlawfully, where she was interrupted by Mr. Brackman, panicked, and killed him.
Thank you, Your Honor. No further questions at this time.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Thank you.
Detective Markowitz, upon your initial investigation into Mackenzie Brackman's death, you found that Brackman was involved as the coach of the CHS mock trial team.
I did, yes.
And at first, you thought it seemed highly unlikely that Brackman's activity with the mock trial team had anything to do with his death.
At the time, yes, but we can all be surprised.
However, you investigated this lead and called one of its members, Alex Cifuentes.
I did.
Cifuentes was the only member that you spoke to on the mock trial team.
Yes. Yes, it was. She was.
You never spoke with Taylor Perkins?
No.
Even though Perkins was the defendant's alibi?
No, I did not speak with Taylor Perkins personally.
And you never spoke with any of the other 9 members of the mock trial team?
I did not.
One of your other initial theories led you to believe that Mr. Brackman could have been murdered by a former client?
Yes, but I disregarded that theory.
And you reviewed the evidence in this case, including your colleague Kyle Kuzak's evidence?
I have.
You were aware of a student named Blair Rollins?
Yes.
Though you never spoke with Blair Rollins?
No, Blair Rollins seemed to have very little relevance to the case at hand.
Even though Blair Rollins disappeared directly following Brackman's murder?
Yes.
And you never interviewed Blair?
No, I did not.
You never even checked his attendance records on the day of the murder?
Again, Blair Rollins had little relevance to the case at hand.
You never even tried to find him since the murder?
No.
And you never investigated any other former clients of Brackman?
I did not.
You never even went to Brackman's office to examine his files?
No.
You never got a list of people he represented?
No.
Now, moving into your area of expertise, detective, concerning cell phone technology, you are aware that a cell phone will not always connect to the nearest tower?
Yes, but usually it will.
So even if a cell phone is far from a tower, there is a possibility it may still connect with it?
A limited possibility, but yes.
Even if that cell phone is closer to another tower?
Yes, it's based on suitability rather than proximity.
So even if Avery Becker's phone was far from a cell phone tower, there is a possibility her phone could have still connected to it?
Yes, although far is a very vague term.
Nevertheless, you concluded that a number of calls were placed by Taylor Perkins on March 6th, is that correct?
Yes.
But you never investigated the call records of Taylor Perkins?
No.
And shifting focus once again, Detective, you received screenshots of a text conversation from Alex Cifuentes.
I did. Ms. Cifuentes had forgotten her phone.
And you never took out a search warrant for Cifuentes' phone yourself?
No, it was unnecessary.
You never even looked at Alex Cifuentes' phone?
I did not need to. She'd sent me the screenshots.
And you never got her phone records?
I did not.
Which is something that you did do with the defendant Avery Becker's phone.
Yes, as Avery Becker was the prime suspect.
But the only evidence you have of these text messages are screenshots.
Yes.
Screenshots sent to you by Cifuentes herself.
Yes.
Screenshots that do not show the date of the text messages.
That is correct.
And they do not show the actual phone number that the text came from.
No.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, counsel. Any redirect?
Yes, Your Honor.
You may.
Detective Markowitz, is it possible for a phone to connect to a more distant tower?
Of course, but it's highly unlikely.
Detective Markowitz, is it possible to track every potential contact on a certain day that Mr. Becker might have had, or excuse me, Mr. Brackman might have had?
No, it would be completely impractical.
Detective Markowitz, did you pursue the most likely theory for who killed Mr. Brackman?
Yes, I did.
Thank you, Your Honor. No further questions at this time.
Thank you. And the people may now call their second witness, please. And counsel, who is your second witness?
Oh, sorry, my internet froze. Kyle Kuzak.
Thank you. And you may proceed.
Please state your name and spell your last for the record.
Kyle Kuzak, Kuzak.
What is your current job?
I'm a crime scene reconstruction investigator with the Denver Police Department.
And how long have you held this position?
I've been working as a crime scene reconstruction investigator for 19 years, and I've been with the Denver Police Department for the past 3.
Are you certified in some way?
Yes. I received a certification from the Colorado Bureau of Investigation.
Have you investigated many crime scenes similar to this one?
Yes, I've worked with several different types of complex crime scenes, including homicides, domestic violence, fatal accidents, armed robberies, burglaries, and other property crimes, and home invasions.
Thank you. Your Honor, I move to have this witness recognized as an expert in crime scene reconstruction.
The objection?
Yes, Your Honor. Permission to voir dire.
You may.
You are not a police officer, is that correct?
No, I'm a civilian employee of the police department.
So you haven't been through the basic training that all police officers go through?
No, as I said, I'm not a police officer, and so I've not received that training. I received training to be a crime scene reconstruction investigator.
Or the same training a police investigator might go through.
I apologize for my dog. Give me a minute.
May I request that this time not be counted as cross time?
You may. There was a few seconds.
I apologize for that.
You don't have to apologize. We can't control our dogs sometimes. So we'll have to continue.
Please repeat the question.
Or the same training that a police investigator might go through?
No, I am not a police investigator. I received training to be a crime scene reconstruction investigator.
Your Honor, I object to the witness's qualification on the grounds that they do not have the same or equivalent training to a police officer or a police investigator.
Thank you. Any response?
We are not trying to enter this witness as an expert in police investigation techniques. We are trying to enter this witness as a crime scene reconstruction expert, and we have shown that she has 19 years of experience in that.
Thank you. Court will overrule the objection and designate the witness as an expert. Thank you. You may continue.
Were you involved in investigating a crime related to this case?
Yes, I was.
Did you visit the crime scene?
Yes.
Have you looked over the evidence collected there?
Yes, I have.
Can you describe for the jury what kinds of evidence and what different pieces of evidence you reviewed?
I looked at several different photographs, as well as the 4 Ring security camera videos and the police reports involved with this case, as well as visiting the scene myself, of course.
What physical evidence did you observe?
When I visited the scene, I observed a broken plate lying on the ground, as well as an open knife drawer, a knife block missing 1 knife, and scuff marks on the floor. I understand that there were a knife, as well as, of course, the body of the deceased, but those had been taken away for processing before I arrived at the scene.
Okay, so you mentioned you saw the Ring doorbell videos. I would like to draw your attention to what has previously been marked for identification purposes as Exhibit 10. Have you seen this?
Just a moment.
Of course.
Yes, I have.
What is this?
This is a video taken from the Ring security cameras by Mr. Brackman's house of the intruder walking towards Mr. Brackman's front door, trying the door, finding it locked, and moving around out of the frame. They are wearing a Red Devil's mask, as well as baggy clothing and surgical gloves.
Okay.
This is.
I would now like to draw.
Objection, Your Honor. That testimony was cumulative. This exhibit has already been entered into evidence, and therefore it should speak to itself.
Your response, counsel?
This is part of the story Ms. Kuzak is telling, and it's part of the evidence that she used in her final conclusions, so I do believe it is important to her testimony.
Your Honor, if I may respond.
Yeah.
Your Honor, if the witness would like to bring in any new evidence which is not already evident within the video itself, that would not be cumulative. But simply restating events which occur in the video is cumulative evidence.
Thank you. And I understand the objection to being cumulative. However, in this circumstance, it does bear upon the expert witness's opinion, and so I'll allow her to testify as to that and overrule the objection. Thank you.
Thank you, Your Honor. I would now like to draw your attention to Exhibit 11. Have you seen this before?
Yes, I have.
What's happening here?
The same intruder as in the previous video is walking around through Mr. Brackman's back gate, entering his property.
Thank you. Could you turn to Exhibit 12, please?
Yes.
Have you seen this?
Yes.
What is it?
This is the Ring security camera of the same intruder as in the previous 2 videos, entering Mr. Brackman's house through his back door.
Thank you. And you mentioned you saw a knife block. If you could turn to Exhibit 8. Have you seen this?
Yes, I have.
What is it?
This is the knife block I described. It is missing 1 knife. It seems to be a slot for a large chef's knife.
Is this a fair and accurate representation of what you examined at the crime scene?
Yes, it is.
Your Honor, I move to enter Exhibit 8 into evidence.
Any objection?
Your Honor, unless I'm mistaken, I believe this has already been entered into evidence.
I don't have it in evidence on my notes, so court will receive into evidence People's Exhibit 8. Thank you.
Thank you. Now could you turn to Exhibit 7?
Yes.
Have you seen this?
Yes, I have.
What is it?
Apologies. This is the open knife drawer I described earlier. It is filled with a variety of different kinds of knives.
Thank you. You mentioned seeing a knife as well. If you could turn to Exhibit 5.
Yes.
Have you seen this?
Yes, this is the photograph I examined for this case of the knife as it was seen at the scene.
Okay. where is this knife located according to the picture?
It is on the floor of Mr. Brackman's front hall.
Okay, thank you. Now could you turn to Exhibit 6? Have you seen this?
Yes, I have.
What is it?
This is the photograph of the same knife, this time at the crime lab when it was taken away for measurement.
Does the size of the wound line up with this?
Yes, it does.
Thank you. Now please turn to Exhibit 18.
Just a moment once again.
Have you seen this?
Yes, I have.
What is it?
This is a photograph taken at the crime scene of the scuff marks I previously described. They are located by the back door of Mr. Brackman's house at the time that this photo was taken.
Thank you. Is this a fair and accurate representation of what you saw at the crime scene?
Yes.
Your Honor, I'd like to enter Exhibit 18, as evidence.
Any objection?
Yes, Your Honor, I would object to relevance. I don't believe the proper foundation has been laid as to why these photographs are relevant to the matter at hand.
The response, counsel. Any response, other people?
Sorry, my screen was frozen. May I respond?
You may, please.
The scuff marks near the back door are an element of the crime scene. They are important to this case because they were located near Mr. Brackman's body and are therefore part and necessary to Ms. Kuzak's investigation.
Thank you. Court will overrule the objection, and you may continue. Thank you.
Thank you. And could you finally turn to Exhibit 13?
Just a moment. Yes.
Have you seen this?
Yes, this is the Ring security camera video I watched for this case of the same intruder, presumably, as in the last 3 videos, exiting Mr. Brackman's house at a run.
Thank you. Have you looked over and analyzed all of these pieces of evidence?
Yes, I have.
And based on your expertise as a crime scene reconstruction investigator, what conclusions did you come to about how the crime occurred?
I believe that an intruder wearing a red devil's mask, baggy clothing, and surgical gloves, as shown in the videos, approached Mr. Brackman's front door. Trying the door and finding it locked, the intruder moves around through the back gate and through the back door, entering Mr. Brackman's property. Mr. Brackman, alerted by the Ring security cameras of the intruder's presence, was ready with a weapon to defend himself, which he had taken from the knife block with one knife missing. A struggle ensued between the intruder and Mr. Brackman, causing the broken plate as well as the scuff marks. During that time, the intruder at some point gained control of the knife and managed to stab Mr. Brackman in his upper left shoulder. Mr. Brackman then releasing the intruder.
I don't believe proper physical evidence to back up all of this. And in addition, I would object on the grounds that this question has created a narrative answer.
Thank you. Any response, counsel?
So, I'm sorry, I couldn't hear your objection. Could you repeat that, please?
Yes, I objected on the grounds of speculation. I don't believe that there's proper physical evidence to back up all of the claims that the witness has made. And in addition, I also made an objection on the grounds that this question has created a narrative.
Okay, may I respond?
Please.
So this is an expert witness, and she is testifying in full to what she believes from her past experience to be the conclusions that she came to based on this. So this is still within the scope of the question.
All right. And the court will overrule the objection, finding that she is expressing her opinion and that it is not beyond the scope of that question. So you may continue, please.
Very well. The intruder, gaining control of the knife, managed to stab Mr. Brackman in the upper left shoulder. Mr. Brackman, then releasing the intruder, allowed the intruder to escape, running and the intruder ran out through the front door. Mr. Brackman pursued the intruder, but rapidly bled out once he pulled out the knife in his shoulder and died on the floor.
Thank you. No further questions, Your Honor.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Thank you.
I'm going to start with some questions about the security camera footage. You are aware that push notifications can be turned off on the Ring app.
That is true, yes.
And you did not obtain records from Ring to see if the victim had disabled push notifications.
No, I did not.
You just assumed that he had them enabled.
Yes.
And you reviewed Blake Van Owen's report for this case.
Yes, I did.
You are aware of Blair Rowland's involvement as a possible suspect.
Yes.
In fact, you regarded Blair Rowland as a possible suspect as well.
Yes.
And you learned that the victim in this case represented Blair Rowland's father in a separate case,
Yes.
where the father was on trial for murder.
Yes.
And through the course of that trial, he was sentenced to life in prison.
Yes.
And you never checked Blair's attendance records for the day of the murder.
No.
And you are aware that Blair Rowland has disappeared following the victim's death,
Yes, I am.
but you never tried to find him.
No, I used the evidence I was provided to recreate what I believe happened at the scene, as is my job.
And you also used a flowchart to keep track of case details for this case.
Yes, I did.
And the details shown in this flowchart are details you learned from an interview with Detective Markowitz.
In part, yes.
Now, moving on to some of the material evidence, it is your opinion that the knife the victim was stabbed with came from the knife block in the kitchen.
Yes.
And this knife had a silver blade and handle cast from one piece of metal.
Objection relevance?
Your Honor, if I may respond.
You may. Thank you.
Your Honor, this question is merely foundational to following questions. It is meant to establish the differences between the knife used as the murder weapon and differences and knives in the knife block.
Thank you. Court will overrule the objection. You may continue.
I'll re-ask the question. And this knife had a silver blade and handle cast from one piece of metal.
Yes, it did.
And the knives in the knife block all have black handles.
Yes.
And upon further inspection of the knife used as the murder weapon, you discovered it was a Chicago cutlery knife.
Yes, it was.
Meanwhile, the knives in the knife block were from a J.A. Hinkle's knife set.
Yes.
So the murder weapon had a different color handle than the knives in the block.
Yes, it did.
It was a different style of make as well,
Yes.
and a different brand.
Yes, it was.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
You may.
So, Ms. Kuzak, did you examine the knife drawer?
Yes, I did.
And looking at that knife drawer, are the knives in there of a consistent pattern?
No, they are not.
So is the knife that Mr. Brackman was killed with of a consistent pattern with those knives?
Well, seeing as there is no real consistent pattern, I suppose it could fit in.
Okay, thank you. No further questions.
Thank you, counsel. And people may now call their third witness, please.
The prosecution calls Alex Cifuentes to the stand.
Thank you. And you may proceed.
Please state your name and spell your last.
And we may have some difficulties with the audio there. The witness could please unmute themselves.
My apologies, did I cut out?
No, you did not. The witness did. So if I have the witness unmute yourself, please.
Oh, I'm sorry. She cut out for me, so I'm sorry.
Oh, there you go. And counsel, I got you start over, please.
Please state your name and spell your last for the record.
Alex Cifuentes, Sifuentes.
And how do you know Miss Becker?
We were best friends, and she was the one that introduced me to mock trial.
How long were you in mock trial?
I was in mock trial for 3 years up until my junior year.
And how was your relationship with the defendant?
Like I said, we were best friends, and she was the one that introduced me to mock trial in my freshman year. She is cut out for me again, so I don't know what I'm supposed to do.
You're okay. Just hang tight. Let's see if she can come back online there.
My apologies. My internet is working up today, I guess. How did you know Mr. Brackman?
He was our mock trial coach for the 3 years that I was in mock trial.
During your time at mock trial, were you able to observe the relationship between Mr. Brackman and the defendant?
Yes, I was.
Could you describe the relationship between the defendant and Mr. Brackman?
They would always get into many arguments.
Did those arguments happen in public?
Yes, many times.
And what were they about?
Miss Becker had an extreme unwillingness to ever prepare for mock trial, and so Mr. Brackman would get very upset with her, and she would make everyone else anxious and frustrated.
Objection, speculation. This witness cannot comment on the feelings of other members of mock trial, only herself.
Any response, counsel?
Am I back?
Yes, ma'am.
Did those arguments ever escalate?
Okay, and I'm addressing the objection, so do you have any response to the objection?
No, sorry, I didn't hear the objection. What was the objection?
This is an objection for speculation. This witness just testified to the feelings of Avery Becker and their feelings for themselves, but not from Alex Cifuentes. That is from Alex Cifuentes' perspective. That cannot be counted as it is speculation.
And then any response, counsel? On behalf of the people, she may have frozen for a moment again.
May I make my response?
Please, thank you.
This was a reasonable inference based on observations, as Ms. Cifuentes had been in mock trial for 3 years at this point, and these arguments happened in public over the same thing.
Thank you. The girl sustained the objection. She can testify about her observations, their demeanor, but not their thoughts. So we'll sustain that objection, and you may continue. Thank you.
Did these arguments ever escalate?
Yes, this one time Mr. Brackman got very angry with Miss Becker, which led to Miss Becker vandalizing his 1986 Porsche 911.
Could you explain the vandalism incident in more detail?
Well, Mr. Brackman tried to explain to Miss Becker why she could not act this way. This made Miss Becker very angry, and she grabbed a Sharpie from the easel and vandalized his car.
Did she answer the question in full? I cut out. I didn't hear her answer completely.
I believe so, but you can ask her if she's got anything else to add. Do you want to repeat?
Do you have anything?
Yeah, go ahead. I'll let you go.
Could you explain the vandalism incident again?
Yes, so Mr. Brackman tried to explain to Miss Becker why she could not act this way. So Miss Becker got very angry, and she grabbed a Sharpie off the easel and vandalized Mr. Brackman's Porsche.
And what did Mr. Brackman do after she vandalized his Porsche? He
kicked her off the team for good.
Did the defendant try and contact you afterwards?
Yes, she texted me and asked me if I could ask Mr. Brackman for her if she could get back on the team.
And did you ask Mr. Brackman for her?
Yes, I did, but he refused.
And what was the defendant's response to the refusal?
She asked me if she told me that she was going to trash and break into Mr. Brackman's house.
Objection. Facts not in evidence. This witness has not established these text messages and is referencing them by word. Therefore, the evidence has to be admitted for this kind of questioning.
Thank you. Any response?
Would you like me to enter it into evidence right now?
If you wish to do so.
Okay. I would like to direct your attention as well as opposing counsel's attention to what has been previously marked for identification purposes as Exhibit 14. Ms. Cifuentes, do you have what has been previously marked as Exhibit 14 in front of you?
Yes, I do.
Could you describe the contents of this photo?
These are the text messages, the screenshots of the text messages that Avery Becker sent me after she got kicked off the team.
And is this a fair and accurate representation of the screenshots?
Yes, it is.
Your Honor, I move what has been previously marked as Exhibit 14 into evidence.
Thank you. Any response? Or any objection?
Yes, Your Honor. I have 3 objections for this piece of evidence. One is just the general authenticity. In order to satisfy a requirement for authenticity, the exhibit has to represent exactly what the proponent claims it is, and as well as a duplicate admissibility objection, because as this is a screenshot, it cannot be admitted. The original is gone, as the phone is now missing, but you can't admit this duplicate because it was destroyed. The original is destroyed in bad faith, as the proponent, Alex Fuentes, sold his phone with these text messages. It is also a hearsay objection. This is an out-of-court statement. An out-of-court statement submitted.
Thank you. Any response?
My apologies, I was frozen.
Did you hear his objection?
Yes.
Okay.
In regards to the hearsay objection, it is a statement of the defendant and therefore it can be excused. All of this goes, and the rest is that all of this goes to the weight, not admissibility of what has occurred.
Thank you. And the court I'm sorry. Certainly, you're welcome to.
Oh, I'm sorry, Your Honor. As to the hearsay objection, it is actually not the statement made by Alex Fuentes. It's made by the defendant, and Alex Fuentes is referencing that statement, which is a hearsay. And to combat the authenticity of it, there is no form of date or timestamps which identify where and when these texts came from, as well as no phone number identifying that these texts were sent by Avery Becker, which makes these unauthentic in nature.
Thank you. And while the objection certainly is well placed, the court will rule the objection. Question is whether these texts are what they purport to be, which is a communication via telephone between the defendant and the witness. As to the hearsay, the court will rule as well, finding that it is a statement against interest and a statement of the defendant. So you may proceed. Thank you.
Ms. Fuentes, were you and the defendant rivals in any way?
Oh, we were very good friends.
Are you here to get the defendant in trouble in any way?
No, I just want this record to be set straight.
One last thing. Was the defendant talented at mock trial?
Yes, she was especially good at manipulating the jury.
No further questions, Your Honor.
All right. Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Thank you.
So, as you said, you were pretty close with Avery Becker.
Yes, I was. We were great friends.
Oh yeah, you were even best friends.
Yes, best friends.
Despite this loving attitude towards Avery Becker, you thought she had a lackadaisical attitude towards mock trial in your eyes.
Yeah, she never really prepared, and that was always a good part of mock trial that you had to do.
And exactly. And you even asked Coach Brackman why he even put up with her.
Yes, I did.
And after, sorry, my dog is trying to testify. Get out of there. All right. And after a dispute between Brackman and Avery, Avery wrote on his car with a marker.
Yes, she did.
And did Brackman want to press charges of vandalism against her?
No, he just kicked her off the team, which is the right thing to do.
But it was you who wished he did.
Yes, but she deserved what she got.
All right. And she was kicked off. Your best friend reached out to you in order to get back on the team.
Yes, she did.
But it was you who didn't even want her back.
No, but I did ask Mr. Brackman for her.
Maybe the relationship with Avery is different, but you definitely thought well of Coach Brackman.
Yes, he was an excellent lawyer.
Yeah, he's not only a great coach, but a person you really cared about.
Yes, he was.
So when Avery apparently texted you a plan to trash his house, you must have warned the police, seeing as you cared for Brackman so much.
I did not.
Maybe not the police, but you definitely warned Coach Brackman.
Yes, I did. No, I didn't. I'm sorry.
You just testified that.
No, I did not.
Oh, so you didn't even warn Brackman, the person you just testified as caring a lot about.
No, I did not.
Either way, Avery apparently admitted she's planning on a vandalism at Brackman's house through text.
Yes, she did.
And looking closely at these texts, which now have been admitted as evidence in Exhibit 14, is Avery's phone number shown anywhere in these texts?
No, it is not.
Are there any timestamps showing when Avery sent these texts to you?
No.
Despite this, the police saw these texts as important and wanted them.
Yes, they did.
So when you attended a police interview about this, you of course brought your phone.
I did not. My phone was very old and damaged, so I left it at home charging by accident.
You didn't even bring your phone to in a police investigation that is getting to the bottom of your beloved coach's murder?
No, I did not. Like I said, it was very old and damaged, and I left it at home charging by accident because the battery would run out very quickly. But the police just said, but the detective that interviewed me said that I could just email him the screenshots.
Of course. And you still claim you love Coach Brackman as a coach and a person?
Yes, I do.
But you didn't even bring potential evidence to help the case.
No, I did not.
So when you got home, you sent the screenshots to the police, which they accepted.
Yes, they did.
Do you have that phone with the confession now?
No, I do not. It got destroyed because it, like I said, it was very old and damaged, but I got a new cell phone.
It was destroyed?
It was destroyed, yes.
Are you sure you didn't sell the phone?
No, I would never do that.
No further questions, Your Honor.
Thank you, counsel. Can you redirect, counsel?
Yes, Your Honor.
Thank you.
Ms. Fuentes, do you hold any ill will towards
No, I do
Ms.
not.
Becker?
No.
And did you take Ms. Becker's threat seriously at the?
Yes, I did.
That's time.
Thank you very much.
My apologies. I think I cut out right as I ran out of time.
You did, and so I think we'll just conclude that was the last question.
Thank you, Your Honor.
Thank you. And that will conclude the people's evidence. Is there any evidence on behalf of the defense?
Yes, Your Honor.
Let me call your first witness, please.
Thank you. The defense would like to call Avery Becker to the stand.
Thank you. And you may
Good
proceed.
afternoon. Thank you, Your Honor. Good afternoon, Ms. Becker. Would you please state your name and spell your last for the record?
My name is Avery Becker. Becker is spelled B-E-C-K-E-R.
Fantastic. And how old are you, Ms. Becker?
I am 18 years old. I just graduated from Colorado High School last year.
And how did you know the late Mackenzie Brackman?
Mr. Brackman was my mock trial coach while I was in high school. So that was our relationship.
And how long were you on the mock trial team?
I was on the mock trial team for all 4 years of high school.
That's a long time. And why did you join the mock trial team?
Well, originally I actually joined to hang out with my friend Taylor Perkins and play on our phones after school. However, after some time, I developed a real passion for the activity and grew to really enjoy it.
From your own perspective, Ms. Becker, what did your relationship look like with the late Coach Brackman?
Well, I mean, Mr. Brackman and I had a lot of conflict during my time in high school and in mock trial. We got into a lot of arguments because we disagreed on how I should be preparing for mock trial, basically all the time.
And despite these arguments, Ms. Becker, were you proud of your accomplishments on the team?
Yeah, I was. I thought I was a very strong team member for the CHS mock trial team.
And nevertheless, were you ever demoted to the B team?
Unfortunately, yes, I was. Shortly before the regional competition last year, I was demoted to the B team by Mr. Brackman after I showed up at practice having prepared my cross-examination differently than he would have liked.
Did you ever regain your position on the A team?
Yeah, so Taylor Perkins came to me and we discussed the issue of how the team would do if I wasn't there, and we came to the decision that since Taylor wasn't that interested in mock trial to begin with, it would be good if they quit the team and I was able to rejoin.
Were you proud of how you performed at the regional tournament?
I thought that we did very well. We went to state and I won some awards that I was pretty proud of.
But how are you received by Brackman and the rest of your team?
Well, I mean, Brackman was not pleased with me at the practice after regionals. We got into a pretty big argument.
And how did that affect you, that argument?
Well, I was pretty angry since I had felt that I had done so well at regionals. So, you know, we got into an argument, I got angry, and I stormed out of practice.
What did you do after you stormed out of practice?
Well, I made an extremely unfortunate decision that I've regretted since, which was to write the words "Worst Attorney Award" across the hood of his car. At the time, I believed that I was writing with a dry erase marker, although that does not excuse my actions. It was absolutely ridiculous that I did that.
And from your own perspective, Ms. Becker, how did Mr. Brackman respond when he saw that?
It seemed to me like he was pretty frustrated. He ended up kicking me off the mock trial team permanently at that point, and that sort of made me even angrier.
And could you elaborate a little more on that anger? How did you feel a little while after the incident?
Well, I went home pretty angry, but after a while and talking to my mom, I kind of cooled down a little bit, and I understood that I needed to apologize to him immediately.
So how long after the incident did you wait to apologize?
I apologized to him, or I attempted to apologize to him the next day.
How were you received when you went to apologize to Mr. Brackman?
Well, I visited his office and his secretary wouldn't let me in. So I didn't get the chance to apologize in person.
Did you give up on apologizing?
Oh, of course not. I both wanted to get back on the team and make amends. I decided I was going to text Brackman with an apology and my plans to help repair his car.
Did Mr. Brackman ever respond to this text?
No, unfortunately, Mr. Brackman was killed before I received a response. It was really unfortunate.
That is unfortunate. And at the time of Coach Brackman's death, did you still feel guilty about his car?
I mean, I still feel guilty about doing that to his car now. Yeah, I certainly did.
And briefly, Ms. Becker, shifting focus, what happened on March 5th, the day before Mr. Brackman's murder?
So on March 5th, I went to school, and then in the afternoon, Taylor and I hung out at the Fry Shack, and then we went to the mall.
Did anything ever happen involving your phone?
Yeah, so the next morning I woke up and I realized that I did not know where my phone was. I had apparently lost it the evening before. Somewhere in the mall in the Fry Shack.
Were you ever able to retrieve your phone?
No, we looked for it basically the whole day of March 6th, and we were unable to find it.
Are you aware of any calls made to that phone on that day?
Oh, of course. So while we were looking for it, Taylor Perkins called it a number of times to see if we could get it to make a sound.
Did you spend the entire day looking for your phone?
Yep.
Was Taylor with you the entirety of that time?
Yeah.
And did you ever intend to go near Mr. Brackman's house?
I mean, we didn't know where he lived to begin with, but we also, I had no reason to go near his car or his house, even if I did, because of my desire to get back on the team.
And switching topics again, Ms. Becker, would you consider yourself close to Alex Cifuentes?
Not really. I mean, Alex and I were on the team together, but we were never close.
And would you have sent any text messages to Alex Cifuentes asking for help?
No, Alex is basically the last person I'd ask for help on anything. I mean, we were never particularly close to one another.
Ms. Becker, is it true you plan to trash Coach Brackman's house?
Of course not. First of all, that wouldn't make sense because I was trying to get back on the team, and burglarizing his house wouldn't help with that.
Of course. And did you plan any other retaliatory acts against Brackman?
No, of course not.
And I hate to ask this, but were you responsible then for the murder of Mackenzie Brackman on March 6th?
I was not, and I can't believe that it happened. It's really unfortunate.
Thank you, Ms. Becker. Your Honor, I have no further questions.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Thank you.
Miss Becker, you were good at mock trial?
Yeah, I would say so.
Exceptionally good.
Yeah.
But your coach, Mr. Brackman, didn't agree.
As I've said, we had a lot of arguments about how.
Objection, Your Honor. Opposing counsel is asking a speculative question. I'm not sure Ms. Becker would know how Mr. Brackman was feeling.
Thank you. Any response?
Yes, Your Honor. The witness has already testified to the many arguments they had on this very topic. I think she has sufficient evidence to say whether he agreed.
Thank you. We'll overrule the objection. You may continue.
I don't think that Brackman necessarily agreed with me. He believed that my preparation techniques were not sufficient. And I thought that they worked pretty well and I got awards. But we definitely got into a lot of arguments.
So you didn't get along?
No, we didn't get along very well.
And this is the same Mr. Brackman who was the victim for this case?
I don't know of any other Mr. Brackmans. Yeah.
So this Mr. Brackman is the victim?
Yeah.
He thought you were lazy.
I mean, that is something that was my opinion during my time in mock trial.
Is that a yes?
Yeah, that's a yes.
He thought you didn't put in the work.
Yeah, I do think that he probably thought that.
And you thought Mr. Brackman was a bad lawyer.
I mean, I definitely had some opinions about how he practiced. However, I did think that he, as a coach, managed to get us to a competitive level, even though we did have a lot of conflict.
Miss Becker, it's not a complex question. You thought Mr. Brackman was a bad lawyer?
Yeah.
You argued with him.
Yeah, we got into arguments a lot. We disagreed on a lot of things.
You argued often.
Yeah.
And then at regionals, you won 2 awards.
Yeah, I did. It was a pretty cool experience.
You earned those awards.
I believed that I did.
But Mr. Brackman didn't think so.
Yeah, we disagreed.
He said you didn't deserve them.
Yep.
And you were angry at this.
I was quite frustrated. I did feel like I had earned those awards.
You were furious, even.
You could say that.
Is that a yes?
Sure.
Is that a yes?
Yes, I was angry.
And you stormed out from your post-regionals practice?
Yeah, I felt quite angry and humiliated, and I didn't really want to argue with Brackman anymore.
And you grabbed a marker on your way out.
Yeah, unfortunately, that is a decision that I'd made.
And you stalked over to his car.
Stalked? I would say that I walked angrily to his car.
Of course. And you scrawled Worst Attorney Award across his hood.
I feel pretty bad about having done that. I think that it was a really terrible decision. It was not an appropriate way to respond to the fact that I was upset, and I realized after the fact that was definitely not the right thing to do.
Excuse me, Miss Becker, please answer the question. You did this.
I believe I did answer the question. Yes, I did do that.
Again, I don't believe that question requires an extended and complex response. You wrote Worst Attorney Award across his hood.
I mean, I feel complicated about having done it. So yes,
did you do it?
Objection, Your Honor. I believe that this has been asked and answered.
Your response.
Your Honor, the witness is refusing to offer a direct answer. It is an easy question to give a yes or no answer to. Did she or did she not do this?
I'll overrule the objection. You may succinctly answer that question. Thank you.
Yes, I certainly did do that.
And this was his prize 1998 white Porsche.
Yes, it was.
And this is when Mr. Brackman finally kicked you off the team.
That was the point at which he kicked me off the team.
And you tried to get back on the team.
Yes, I did.
Mr. Brackman never responded.
Unfortunately, he never responded to my text of apology before he died.
And you spoke to your mother about this matter.
Yeah, I did.
And you said you'd get back at Mr. Brackman.
I did say that. In a bit of an angry moment, after I cooled down, I realized that I definitely needed to apologize. But yes, I did say that, and it was definitely not the right thing to say.
Of course, you didn't tell your mother about the car.
Objection, Your Honor. I believe this is improper character evidence. I think what the opposing counsel is trying to do is extrapolate what Avery Becker would be doing in one situation to another situation.
May I respond, Your Honor?
Please.
Improper character evidence it comes into effect when one side attempts to prove that having acted in accordance with a character in one instance, the defendant will do so again. I am not attempting to prove that the defendant will once again, after having done something bad, not tell her mother about it. I am expanding on the relationship between Miss Becker and Mr. Brackman.
All right, thank you. So the court will overrule the objection. May answer the question.
You didn't tell your mother about the car?
I did not, which is a lie that I regret.
Now, Miss Becker, Taylor Perkins is your friend?
I would say so, yes.
Your best friend?
Yeah.
When you were demoted, Taylor quit the A team.
We both felt that it would be the best thing for the whole team.
And that allowed you to return to the A team?
Yep.
After Mr. Brackman had demoted you?
Yes.
For not putting in the work?
I suppose that was his opinion. I wouldn't agree, but I suppose that would be what he would say.
And Taylor Perkins helped search for your phone?
Yep.
On March 6th?
Yeah.
Skipping school?
Yep.
All day?
Yeah, it took a long time to search for it.
To help you?
Mm-hmm.
And now, on March 5th, you were at Fry Shack?
Yep.
Speaking with other students?
Yeah, so while we were there, some other students from mock trial came into the restaurant. It was a pretty popular place for students to hang out.
You had your phone?
Yeah, I did.
This is the phone you can't use at home.
Well, I can use it when I'm not doing my homework.
It's the phone that you're not allowed often to use at home.
I guess you could say that. I use it many hours of the day, just not when I'm doing my homework.
Your mother doesn't let you use it.
That was the rule in my house.
Is that a yes?
Yeah, that's the rule.
And this is the same phone you would use to text?
Yes.
At mock trial?
Yeah.
With Taylor Perkins?
Yep.
Because you couldn't text at home?
In the evenings, I wasn't allowed to.
And you said earlier you joined mock trial in part so you could do this.
Yeah, that was definitely part of my reason for joining.
This is the same phone you searched for?
Yeah.
For most of March 6th?
Yep.
Skipping school?
Yes.
Searching for hours?
Yes. I mean, the mall is pretty big, so it took a while to look around everywhere.
Oh, and you went all over the mall?
Yes.
In the search for this phone?
I believe that's how most people would search for a phone.
And this is the phone you forgot?
Objection, Your Honor. I believe many of these questions have been asked and answered.
Your response?
Your Honor, I have not asked regarding whether she forgot the phone, and these questions have elicited new facts and new relations between Miss Becker and her phone.
Thank you. Court will overrule the objection. You may continue.
This is the phone you forgot.
Could you please clarify the timing of when I forgot it?
This is the phone you forgot from the evening of March 5th to the morning of March 6th?
I mean, I didn't have it on my person during that time because I had lost it. And I completely didn't notice that I had lost it, particularly since it was the evening and I'm not allowed to use my phone when I'm at home doing homework. So that's the time when I normally would be off of my phone. So
You didn't notice you didn't have it, you forgot?
yeah, I didn't notice.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect, counsel?
Yes, Your Honor.
Thank you.
Ms. Becker, would you call your relationship with Mackenzie Brackman violent?
course not. I mean, we had arguments, but we were never aggressive towards each other in that way.
And after the incident involving his car, how long did you take to realize the fault of your actions?
A couple of hours. I mean, I realized within that evening.
Let me just pause.
Were you still?
I was going to have Mr. Hanson mute himself, but it appears he has. Okay, thank you. May continue.
Thank you. And Ms. Becker, do you still feel guilty about this incident?
I still feel terrible about a lot of the ways that I behaved to Brackman, most especially in regards to his car.
And would you have therefore wanted to further strain that relationship by carrying out any other retaliatory acts?
No, I mean, I wanted to apologize to Brackman and I wanted to be back on the mock trial team. And so it would have made no sense and, you know, very little impact to have, or rather negative impact to have retaliated against him in any way.
Thank you, Ms. Becker. Your Honor, I have no further questions.
Thank you. And the defense may call its second witness now, please.
Yes, Your Honor. The defense would like to call Taylor Perkins to the stand.
Very well, thank you.
Good morning, Mr. Perkins. Please state your name and spell the last for the record.
Hi there. My name is Taylor Perkins, the last name being spelled Perkins.
Wonderful, Mr. Perkins. And how old are you?
Right now I am 19 years old.
Where did you go to high school?
Well, last year I graduated from Colorado High School, but we really just called it CHS.
And what is your relationship with Avery Becker?
Oh, Avery? Avery and I are best friends. You could even call us besties. We're definitely super close with each other.
And how long has this friendship lasted?
Geez, we've been friends for almost as long as either of us can remember. Definitely for a super long time.
And were you in mock trial with Avery?
Yes, actually I was. Funnily enough, it was actually Avery that suggested that we join mock trial, and we joined our freshman year and stuck with it through almost all of our senior year.
And besides mock trial, did you often hang out inside or outside of school?
Oh, you betcha. We'd hang out all the time. We'd either be carpooling to school, sharing a lot of our class together. I mean, even the super boring ones. We'd go to mock trial together after school and even hang out at the mall a lot.
And speaking of mock trial, how was Avery as a member of mock trial?
Oh, Avery as an attorney was incredible. I mean, you really just had to see it. But as a team member, she could sometimes show up a little underprepared.
And how did Coach Brackman react to this unpreparedness in your view?
In my view, Brackman was always super upset with her. I mean, he always wanted her to do what he said, and when she wasn't, he was always yelling at her.
And was Avery ever demoted for this kind of behavior?
Yes, unfortunately.
Objection, leading question.
Your response, counsel.
I'm not leading this witness anything. He is allowed to describe any kind of relationship or reaction to Brackman in his view. This is not a yes or no answer question.
Thank you. So I'll overrule the objection. You may continue.
Could you re-ask the question, please?
And was Avery ever demoted for this kind of behavior?
Oh, yeah. One of the practice, Avery showed up the most unprepared I think I'd ever seen her. I mean, it was pretty bad, but Brackman just decided that he had enough of her and just demoted her.
And what did you do after this happened?
Well, I was torn. I knew that the team wouldn't be able to do as well without Avery, and even though I was a part of it, it was really Avery's thing. So I decided to step down and let Avery take my place.
And unpreparedness seems to be one concern for Coach Brackman, but from your view, how is Avery and Brackman's relationship as a whole?
The relationship was always fairly negative. I mean, whenever she was unprepared, Brackman was always yelling at her, and he got angry to the point where he was almost like tomato-faced, or he was red in the face.
And did this strenuous relationship ever result in anything serious?
Yes. The only serious thing that came out of that relationship was what I've dubbed as the car incident. You see, Avery told me that one day after practice, Brackman was absolutely berating her, and she got upset. So, I mean, she'd always pull pranks, so she grabbed a marker and decided to try to draw, or she wrote worst attorney award across the hood of his car.
What was Avery's reaction to this scuffle in your view?
I mean, I saw Avery afterwards, and she became extremely apologetic and was even visibly worried. I mean, Avery's always been the type of person to try to make things right again.
And what did you two do the day before Brackman's murder, March 5th?
Well, Avery was really down in a slump. I mean, mock trial was a big part of her life at this point. And, well, I really wanted to bring her up again and to get rid of all that stress she had built up. So I decided I'd take her to the mall and more specifically to the Fry Shack.
And did anyone else show up to the Fry Shack?
Unfortunately, yes. Later in the day when we were at the Fry Shack, other members of the mock trial team started to trickle in, and more specifically, Alex Cifuentes. Alex Cifuentes was being super passive-aggressive in this totally insincere way towards Avery and made Avery storm off.
And moving on to the day of the murder, March 6th, what were you doing?
Well, remember when I said that Avery had stormed off? She had forgotten her phone, so I went with Avery to go help her look for it.
And where was the last place exactly you saw this phone?
Well, after Avery had stormed off, she had left it on the table near Alex Cifuentes.
And where did you look for this phone?
Well, we began just by looking all over, but eventually went to the different locations at the mall because that's where we had been the previous night.
And how did you look for this phone?
Oh, every time we'd enter a new location, we just try to call it. We thought that maybe the ringtone would help us alert us, or would alert us to where it is, but we never heard it and nobody ever picked up.
And was calling the only way to find the phone?
Well, at the time, it was the only thing we had thought of, but in hindsight, we realized that we could have used the iCloud tracking website to locate it, but I have Avery has an iPhone and I have an Android, so I never thought of it.
And so on the day of Brackman's murder, March 6th, you were with Avery all day?
The whole day looking for that cell phone.
Did Avery ever leave your side, even for a minute?
No, Avery was my ride there, and if Avery left, I would just be stranded there.
You went to the mall, the Fry Shack, but did you ever go to Coach Brackman's house?
No, we never even knew the address of Coach Brackman's house, so we definitely didn't go there.
Was there even a reason to go to Coach Brackman's house?
No, not at all.
Based on this, did Avery kill Coach Brackman?
No, I can say with 100% certainty that Avery never killed Coach Brackman.
Thank you, Your Honor. No further questions.
Counsel, any cross-examination?
Yes, Your Honor.
Thank you.
May I proceed? You know Miss Becker well?
Oh yeah, we're besties.
You're around Miss Becker a lot.
Oh yeah, we'd hang out a lot of, we'd spend a lot of our time together, especially during school and afterwards.
You were on the mock trial team together?
Yeah, Avery convinced me to join and we stuck with it together.
So you saw a lot of Miss Becker and Mr. Brackman's interactions.
Yes, I did see a lot of their interactions together.
In your view, Miss Becker and Mr. Brackman had a rocky relationship?
Yes, their relationship was always negative and it would even sometimes bother Avery.
So just before regionals last year, Miss Becker was demoted to B team?
Well, that's what I heard. Yeah. Or sorry, I apologize. Yes, that's exactly what happened.
This was as a result of Mr. Brackman finding her unprepared?
Yes, like I was saying earlier, she showed up super unprepared to practice and Brackman just had enough of her.
So you gave up your spot?
I mean, yeah, I had to think about it for a pretty long time, but I knew it was right for the team and for Avery.
To help her get back on the team?
I mean, yeah, being a lawyer was always Avery's shtick, and I don't even want to become a lawyer when I'm older, so I gave up my position.
Okay. Miss Becker and Mr. Brackman got into an argument over this turn of events?
I only heard that from Avery, but yeah.
So she stormed out?
Once again, yeah, that's what Avery told me.
Okay. And on the way, according to Avery, grabbed a permanent marker?
No, well, Avery actually told me that she had thought she'd grabbed a dry erase marker, once again, just pulling a prank on Brackman because she was pretty upset, but she only told me later that it had been a permanent marker.
But she still grabbed a permanent marker on her way out?
Yeah, apparently she did.
Okay. And after getting the marker, Miss Becker then went and wrote on Mr. Brackman's car?
Yeah, that's what Avery said she did.
Okay. In permanent marker?
Objection. This is just speculation. As much as Avery did inform Taylor Perkins of the following events, Taylor Perkins cannot comment onto the exact specifics of all of this.
Your response, counsel.
Mr. Perkins and Miss Becker are best friends, and Miss Becker has told Mr. Perkins about these events. He has sufficient background knowledge to answer these questions.
Thank you. Overrule the objection. You may continue.
Thank you. I'll ask that question again. In permanent marker?
Yeah, I was in permanent marker.
And Mr. Brackman kicked her off the team after this?
I mean, yeah, Avery told me that he walked out and was absolutely devastated to see his car. So he just had enough of her and kicked her off.
And Miss Becker tried to get back on the team in multiple ways. Is that correct?
Oh, yeah, most certainly. Avery was extremely apologetic, and she tried to get other people to text, or she texted other people trying to let them apologize to Brackman for her, but he never had any of it.
And Mr. Brackman still refused, yes?
Yeah, he never let her back on the team.
Okay. You and Miss Becker ran into the mock trial team on March 5th.
Oh, yeah. Once again, we were at the mall and at the Fry Shack, and some members of the mock trial team trickled in.
And once again, she stormed off?
Well, yeah. Alex was being totally insincere and passive aggressive. It's almost as if she didn't even want her back on the team.
So you talked to Alex Cifuentes while Miss Becker was away?
Briefly, yes.
And she did express sympathy for Miss Becker's situation.
Well, she was expressing sympathy, but it was totally passive aggressive and insincere. I don't really think she meant it.
So she expressed sympathy for Miss Becker's situation?
That's what her words might have been, but not her feelings.
I'm not sure. Okay. You and Miss Becker both left shortly after this?
Yes. Avery was super upset from Alex and just walked away from the mall.
Okay. However, you do not remember whether Miss Becker retrieved her phone before leaving?
No, but that is the last place that I saw it. So.
Okay. You saw Miss Becker on the morning of March 6th, pardon?
Mm-hmm. She was my method to get to school. We carpooled a lot in the mornings. So yeah, she ended up coming to my house.
And you both claim that then and only then did you realize that her phone was missing?
Well, Avery, I think, realized it a little bit before because I was texting and calling her, but she just wasn't responding. But when she arrived, she confirmed it.
After almost a whole night of her not having her phone?
I mean, when I realized there's no other way I could have known.
When you yourself has said that Miss Becker's phone was so important to her, it was like a third kidney?
Yes, she was on that thing all the time, and it was fairly important to her.
Okay. And after you both realized this, a number of hours after Miss Becker supposedly lost her phone, you two decided to retrace your steps?
Oh, yeah, we went to the mall because that's where we had been the last night.
And you did this all day?
Well, I mean, the mall's really big, and we did try to search all over. I mean, we went to every location, even tried to call it, and we asked around, but it never showed up.
Just you two were searching?
Yeah, but we even saw some other members of the mock trial team there later in the evening.
Okay. Your Honor, I have nothing further. Thank you.
Thank you, counsel. Any redirect?
Yes, Your Honor.
Thank you.
You tried calling and texting Avery, but she was not responding.
Yeah, in the morning, like we had planned, we were going to carpool to school together, but every time I call and text it, it'd just go unread or unnoticed.
Is there any kind of extenuating circumstances that would make her not pay attention to her phone the night of March 5th when it went missing?
Oh, yeah. Alex was just berating her over, well, she was being really passive aggressive towards her and made Avery storm off to the bathroom.
And was, from your view, Avery pretty emotional?
Oh, yeah. She was really upset with what Alex Cifuentes was saying. I mean, it was, mock trial was a lot to her. And yeah.
Was searching for the phone an all-day task?
Most certainly. We began in the morning and skipped class, but we were never able to find it.
And did this task, why was this task taking so long?
Well, as I said again, we never thought about using the iCloud tracking website. So we went to every location we'd visited the previous day and each and every different of the outlets at the mall and would call in every location we were at. But once again, yeah, we never found it.
Objection, the question called for speculation.
Response, counsel?
The objection did not call for speculation. The witness just testified to exactly what they were doing and why it took so long. That's not speculation, as the witness did it himself. They called the phone over and over again until they could try to find it.
Thank you. Overrule the objection, please.
No further questions, Your Honor.
All right, thank you. And I believe the defense has their third witness.
Yes, Your Honor. The defense would like to call Professor Blake Van Owen to the stand.
Very well, you may.
Are the timekeepers ready?
Yes.
And may I request how much time is remaining?
Sorry, what was that?
May I request how much time is remaining?
You have 8 minutes and 35 seconds.
Thank you. Could you please state your full name and spell the last for the record?
My name is Blake Van Owen, last name spelled Vanowen.
And would you tell the jury your connection to this case?
Yes, I've been consulted by the defense to do police work and general investigation for the defense team.
How did your career in law enforcement begin?
I worked as a police officer for the Aurora Police Department, but shortly after moved on to other fields.
Why did you decide to leave the Aurora Police Department?
There was a certain incident in which a detainee of mine was injured during an arrest, and I sought to amend the issues I saw within the criminal justice program from the outside by working as a private investigator.
Were you fully cleared of any wrongdoing from that incident?
I was, yes.
What did you do after leaving the police department?
I did a multitude of jobs from when I worked at school as a resource officer. I also got my online master's degree from Ashford University in criminal justice and began teaching courses at Community College of the Rockies and CU Denver.
Do you frequently appear as a witness in court?
I do, multiple times, yes.
When you appear in court, what areas of expertise do you testify on?
A wide range: general police practices, cell phone tower data analysis, crime scene reconstruction, etc.
In how many states have you been accepted as an expert in district courts?
I believe 3 states, those of Arizona, Colorado, and Kansas.
And in how many states have you been accepted as an expert in state courts?
4 states, Colorado, New Mexico, Nebraska, and Wyoming.
How many times have you been accepted as an expert in crime scene reconstruction?
8 times.
How many times in cell tower analysis?
5 times.
General police investigation tactics?
12 times.
And how many total cases have you consulted in?
I'd say almost 100.
Your Honor, I would like to qualify Professor Van Owen as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics on the grounds of his extensive education and experience in these fields under Rule 702.
Thank you. Any objection?
No objections, Your Honor.
Thank you. Court also designate. You may continue.
Thank you, Your Honor. In your work on the case at hand, what police evidence did you review informing your opinion of the case?
I evaluated the evidence gathered by Detective Markowitz and Kyle Kuzak.
I'm going to ask you now about some of your specific issues with Kuzak's conclusions. What is Kuzak's theory about how the confrontation occurred between the victim and the intruder in the victim's home?
Kuzak believes that there was an intruder who entered the home and, in a scuffle with Mr. Brackman, stabbed the victim in the back.
What evidence did Kuzak use to back up this theory?
Kuzak cites scuff marks near the entrance, as well as the certain angle of the knife.
Do you take any issue with the scuff marks?
I do. The scuff marks could in no way be connected to this particular case. They could be totally unrelated to the actual murder.
Is there any evidence to contradict Kuzak's theory?
There certainly is. As alluded to earlier, the knife did not match the other knives in the knife block, thus not really affirming the theory that Brackman would have grabbed that from that particular block.
Moving on, are you aware that Brackman had Ring doorbells set up at his residence?
I am aware of that, yes.
Did the police make an investigation to determine if Brackman had push notifications on for these doorbells?
They did not know.
Would this have been within their power?
Certainly, yes.
Let's move on to your evaluation of Detective Markowitz's investigation. Were you present in the courtroom today during the testimony of Taylor Perkins?
I was, yes.
Do you recall Perkins' statement that during the time of the murder, Perkins and Avery were searching for Avery's lost phone at the mall?
I did hear that testimony, yes.
Were you aware of this fact prior to the trial today?
I was.
Since Avery did not have their phone during the time of the murder, even if the cell tower records indicated that their phone was near the victim's house, would that mean that Avery was near the victim's house?
No, as that's equating one's phone to the actual person themselves. A phone being near the vicinity does not in any way guarantee that that person is in that vicinity.
Did the detectives look at the cell tower data for Taylor Perkins' phone?
They did not, no.
Would it have been within their power to access this data?
It certainly was, and I see it as an oversight on their part.
Did you view the cell tower data for Taylor Perkins' phone?
I certainly did.
What does this data indicate?
This data from the story earlier told by Taylor that Taylor was at the mall, presumably with Avery, to find the phone.
In reviewing the evidence for this case, did you view the screenshots of the text messages shown in Exhibit 14?
I did, yes.
Do you take any issue with these screenshots?
I certainly do. Again, the issues have been brought up, but the lack of a timestamp, no real confirmation that the person in that message is actually Miss Becker, a multitude of issues as to its authenticity.
Would it have been within the power of the police to verify that these messages were actually sent from Avery's phone?
Certainly, a simple consultation with Cifuentes would have been able to affirm that.
And during your investigation, did you develop any other suspects for this crime?
Yes, one Blair Rollins.
What was Blair Rollins' involvement to Brackman?
Blair Rollins' father, Jonathan Rollins, had been convicted to a life sentence as a result of not being able to win a case with Mr. Brackman as his attorney.
Is Blair Rollins roughly the same build as Avery Becker?
Yes.
Where is Blair Rollins now?
I do not know.
Have you tried to find Blair Rollins?
I've tried very hard and I have not been able to find Rollins, no.
Can you determine whether he is in the state of Colorado?
I cannot, no.
Did the police ever investigate Blair Rollins?
No, they briefly alluded to the possibility of him as a suspect, but no.
And when you investigated Blair Rollins, did you view his attendance records on the day of the murder?
I did.
Was Blair Rollins in school on the day the murder took place?
No.
Thank you, Your Honor. No further questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor.
Thank you.
Professor Van Owen, you are a police officer?
I was, yes.
For 9 months?
Yes, at the Aurora Police Department.
Until there was an incident?
Yes, that incident revealed to me that there were many issues within the justice system and that I would better spend my time outside of it reforming, if you will.
And you injured a young woman of color?
Yeah, unfortunately, yes. And we reached a settlement deal in which we reached a settlement, yes.
Objection, Your Honor. I believe this qualifies as unfair character evidence under Rule 404.
Response, counsel?
This line of questioning shows bias against police departments.
Thank you. Court will rule the objection, and you may continue.
So you ended up leaving the police?
I did, yes.
And you started teaching?
Yeah, I taught at the Community College of the Rockies, and then I sought higher education through an online course at Ashford University, prompting me to teach courses at CU Denver, thus earning me the title of Professor Van Owen.
And you consider yourself a check on the power of police now?
Yes, I feel many private investigators would likely describe themselves as that.
And now you testify as a defense expert?
Again, like a number of private investigators, I see my job is to find possible issues within the police work, yes.
And you've only ever testified as a defense expert?
To reiterate my past point, it is a common practice for such private investigators to testify for the defense.
You've met Mr. Cusack before?
Yes, I have worked with Cusack before.
I believe you cut out there for a moment, Ms.
Let's just be.
My apologies for my
You don't have to
internet. Would you like me to restate the question?
Yes.
Would you like me to repeat the question?
Please, yes.
Professor Van Owen, you've met Mr. Cusack before?
I have, yes.
And you like him?
No, not, I wouldn't say like. I have some issues with how Cusack conducts investigations.
You don't think Detective Markowitz, then, is very good at his job either?
I don't know if I'd frame it that way. I'd say that some of the conclusions that Markowitz reaches are a bit hasty and not quite up to par with what I would expect from a detective.
So you don't think he's good at his job?
To put it in those terms, certainly.
And you think Detective Markowitz influenced Mr. Cusack's findings?
Yes, I think both of them developed a similar case with each other, building on each other's evidence to reach their final conclusion.
And Professor Van Owen, you're being paid to be here?
Yes, I have a fee, again, common practice for private investigators.
And as of right now, you've charged $7,000?
Yep, that's the common amount that I would charge for a case like this.
But you expect it will increase by at least 1,000?
Yes, that's specifically for me providing testimony as to what I found.
No further questions, Your Honor.
Thank you, counsel. Any redirect?
Your Honor.
Thank you.
Are you being paid to testify here in court today?
I am, yes.
Is it normal for private investigators to be paid to testify?
It'd be bizarre if they were not paid, as that is the primary job of a private investigator.
And when you've testified in the past, what side of the case do you typically testify for?
Always defense. The prosecution is always inclined to have members of the police force within testifying on their behalf, and thus to even out that imbalance, I often try to provide a more equal side of the story by testifying for the defense.
So is it normal for private investigators to testify only for the defense?
As alluded to, it's a common practice within this career.
Thank you, Your Honor. No further questions.
Thank you. And at this point, the evidence has been concluded. We'll move forward to closing arguments. On behalf of the prosecution, you may begin. Thank you.
Avery Becker has always assumed she was immune from consequence. She assumed there would be no consequences for her poor effort in mock trial. She assumed there would be no consequences for her vandalism of her coach's car. And ultimately, she assumed there would be no consequences for her attempted burglary of his house. When Miss Becker came to Mr. Brackman's home on March 6th, she had the explicit and stated intent to commit a second-degree burglary. When she came surreptitiously, uninvited, illegally. When Miss Becker left Mr. Brackman's home, she left Mr. Brackman lying in a pool of his own blood, alone, spilled from wounds that she herself created. In this act, Miss Becker became guilty as well as of a first-degree felony murder. Miss Becker is wrong and always has been. She cannot escape the consequences of her actions, especially when those consequences are mandated by the law. Members of the jury, it is your duty today to enforce those consequences and find Miss Becker guilty of these acts. Mr. Brackman has already suffered the consequences for Miss Becker's rash actions. It is time that she do the same. Now, two separate experts examined this crime scene. Both came to the conclusion that Avery Becker is guilty. Kyle Cusack performed an expert crime scene reconstruction, a reconstruction which reinforces the fact that the intruder on March 6th intended to burglarize and not to kill Mackenzie Brackman. This, aligns with what the prosecution argues. The prosecution does not argue that Miss Becker was so foolish as to premeditate this murder. However, Mr. Brackman did die in the course of her burglary. This constitutes first-degree felony murder. This is why Miss Becker is guilty. At the same time, Detective Jordan Markowitz brings a vital connection to the case. Because of her, we know that Miss Becker's phone traveled from her own home directly to the home of Mr. Brackman, where it remained for an extended period as Miss Becker committed this crime. This is the same phone which Miss Becker is never without. This is the phone that traces Miss Becker's guilt. Now, Blair Rawlins represents the feeble attempts of the defense to create an alternate suspect for this case. It is an argument which requires the utmost contortions and depends on a series of perfectly random connections that defy belief. There is no reason to put any stock in this theory, and further, the very idea of a lost phone is at best a flawed fantasy. You don't use texts while searching for a lost phone. They don't produce a ringtone. They're thoroughly unhelpful. And yet, of the 5 contacts made that day between 12:40 and 1:30 p.m., 3, more than half, were indeed texts. We can be sure that those contacts are not 2 friends looking for a lost item. The prosecution has their case. The defense must contest it then. And each of their witnesses is corrupted in their own way by bias. Miss Becker has every reason to seek to avoid jail. Taylor Perkins, Miss Becker's best friend, as always, stays on message, toes her line. Professor Van Owen is the defense's only expert witness, and her own testimony is corrupted by her universal paranoia for the police. She cannot contest well-credentialed experts Kyle Cusack and Detective Jordan Markowitz. Members of the jury, you must not allow Miss Becker's consistent trend of avoiding consequences to continue. The consequences today are mandated by the law. The prosecution has brought a solid case, founded in fact, entrenched in evidence. Evidence and fact which defense can only refute imperfectly. There is no room today for reasonable doubt. So today, you must find Miss Avery Becker guilty of second-degree burglary and first-degree felony murder.
Thank you, counsel. In closing argument on behalf of the defense.
Are the timekeepers ready?
Yes.
Ladies and gentlemen, the mere fact that we are here in court today is a gross miscarriage of justice by the Denver Police Department. Humans are complex creatures with complex problems. The police investigation in this case is an effort to explain a complex problem with a simple solution that simply doesn't fit. From the beginning of the investigation, Markowitz and Cusack made up their minds about who they thought had committed this crime and followed only the lines of evidence which suited their premature conclusions, despite the fact that these conclusions simply do not make sense in context. In each and every foundational piece of evidence to the prosecution's case, they've failed to properly establish that evidence. The most important piece of evidence to their case, in fact, the only piece of evidence which could potentially tie Avery Becker to these crimes, is the series of text messages provided by Alex Cifuentes. These text messages do not show the time, nor the date, nor the phone number of the sender. And now, based entirely on Cifuentes' word that these messages came from Avery, the police are trying to convict an innocent person of a crime she did not commit. Searching Cifuentes' phone to verify the validity of these messages was well within the rights and abilities of the police department, but they neglected to carry out this vital step of the investigation. This gross incompetence simply cannot be held up in court as an imitation of a proper investigation. In addition to failing to properly establish their own evidence, the police have also failed to failed to consider evidence which did not suit their theory. The police tried to use cell tower analysis of Avery Becker's phone to try to prove that Avery Becker was near the house of the victim around the time the murder occurred. However, cell tower analysis cannot be relied on to show the exact location of a device. And even so, Avery Becker was not in possession of her phone at the time, having lost it the previous night. At the time of the murder, Avery and Taylor were at the mall trying to find her lost phone, an alibi the police completely neglected to investigate. The police could have looked at Taylor Perkins' cell tower data to substantiate this alibi, but once again, they neglected to do so. However, Professor Blake Van Owen did view the data, and Taylor's cell tower data shows that they were at the mall when the murder took place. Now consider this. In either theory of this case, someone has to be lying. Either Alex Cifuentes is lying about being sent these messages by Avery, or Taylor Perkins is lying about Avery being with him at the mall when the murder took place. No evidence exists to prove that Cifuentes received these messages from Avery. However, Taylor's cell tower data does prove that she was at the mall when the murder took place. The police elected to ignore this fact because it does not suit their premature and unfounded theory. In failing to consider other theories, the police ignored any other possible suspects they encountered along the way, such as Blair Rollins. One way or another, the police were aware that Blair Rollins fled the state following when the murder occurred, and after Brackman had lost a case wherein Blair's father was sentenced to life in prison. Even with such a compelling suspect, the police elected not to investigate because it did not suit their theory. It is clear that the police had already made up their minds about who they thought had committed this crime and followed only the lines of evidence which suited their premature and unfounded conclusions. Now, Avery Becker, in all reality, is just a kid. And yes, when she got kicked off the mock trial team, she was angry. But it is completely absurd that a simple and harmless disagreement over something as mundane as mock trial is being presented as a motive for murder. The burden of proof today is on the prosecution. They must prove beyond a reasonable doubt that Avery Becker has committed these crimes. You may find reasonable doubt in the inability of the police to establish the validity of the text messages, in their firm resolve to ignore any evidence which did not suit their theory, in their outlandish conclusions based on the cell tower data, in the absurdity of a mock trial dispute being presented as a motive for murder, or in the glaring fact that at the time of the murder, Avery Becker was with their friend Taylor Perkins at the mall. And as everyone knows, you can't be in two places at once. This case is a gross miscarriage of justice by the Denver Police Department, a window into their incompetencies, and an effort to explain a complex problem with a simple solution that simply doesn't fit. Nothing about the prosecution's theory of this case makes sense. Return a verdict of not guilty.
All right, thank you, counsel. And I want to thank everyone.
Excuse me,
yes.
Your Honor.
Oh, I apologize, you had rebuttal. Thank you.
And first, if I may, had I been able to object, I would have objected speculation and facts, not in evidence. We do not know the location of Blair Rollins, and yet the defense argued that Blair Rollins had fled the state.
That's noted. Thank you.
May I have a time check before I proceed?
Yes, please.
15 seconds.
Camille, Ms. Vaughn, could you please respond alone? It was a bit hard to hear, as long as it...
Yes, we both have 15 seconds.
Thank you.
Thank you.
The explanation of the defense isn't complex, it's absurd. There is no evidence for a number of facts, and ultimately, their arguments are insufficient to withstand the weight of evidence. Find Avery Becker guilty.
Thank you, Counsel. And as I was saying, thank you to everyone. I want to give the scores the opportunity to complete their sheets. And if they have any statements, I certainly want to invite them. I'll just sort of highlight, I've been doing this off and on probably for about 10 years now. And I just continue to be impressed with the level of professionalism today, the passionate arguments that were made on both sides, really persuasive arguments, the objections. And I'll just say this, if you have a good faith belief, make the objection. I know I overruled a number of objections today, but whether I was right or wrong, the bottom line is if you're making a record for appellate purposes, and so if you believe you have a good faith reason, make the objection, and even if the judge makes a mistake, you preserve that. I appreciate everyone sort of just getting through the the whole Zoom experiences. Our comfort animals sometimes get in our way. The internet doesn't always work. Just connecting and doing this is a new world. So it was very pleasurable, and I want to say congratulations to everyone. You all did a really, really impressive job.